And I'm sure there's a reason why they did not approve her living with her parents. And part of that reason is because of the drinking. And they knew that they had probably already tried that before with her living at home, and they told her no, but she wanted to do what she wanted to do. So now we're here, and I don't think she's a good candidate for probation. All right, Garcia Garcia. Oh, hey, it's Dasia. How do you pronounce that? Where is the J coming in? Somebody explain to me what?
name is Garcia and it's Deja.
No, here's my question. Yeah, but I mean, it's Dasia. Well, I mean, how do you pronounce your name?
Deja.
All right, I'm going to go with Deja, but I'm telling you all right now, I'm pronouncing it that way because that's how she says pronounce it. But there is no way you're getting a J from a Dasia. And then all of those vowels are not supposed to be talking. The only one that's supposed to be talking is the A and the I. Thank you. Thank you, Bianca.
That is Asia. We have to think about that way. So Asia, like Asia.
Well, then there should be a hyphen or either, yes, thank you. A hyphen or either apostrophe. So it's Deja.
Deja. Deja.
You know what somebody told me forest is? How they spell forest? 4 Fs, because it's forest, 4 Fs. All right, I'm sorry. So Deja Garcia. All right. Are y'all ready to proceed?
Judge, do you have the court summary in that file?
Let me see what I have here. Is this the court summary that I really need to read?
No, Judge.
Okay. All right. Court is calling 2022 CR 2514 State versus Deja Garcia. Could I have parties announced?
Megan Galloway for the state.
Teresa Max Vasquez for the defense, Judge.
And are you Deja Garcia?
Yes, ma'am.
All right, Ms. Garcia, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Deja Rosette Garcia who was placed on deferred adjudication in 2022 CR 2514 for the offense of attempting to take a weapon from an officer on May 26, 2022 for a period of 3 years? Is that you?
Yes.
All right, state.
Violation of condition number 41 on or about the 17th day of April 2025 in Bexar County, Texas. The defendant Deja Rosette Garcia did then and there fail to comply with the rules and regulations of the felony drug court by tampering with drug patch in violation of condition number 41.
How do you plead to that? True or not true?
Not true.
All right.
I guess I need to talk to the attorney because I thought something different was happening.
Okay. All right.
We could just step back for
Sure.
5 seconds.
All right. Thank you.
Judge, if I could, well, we're gonna go back on the
Sure,
record.
we're
I'm
back
gonna
on the record.
withdraw the condition of violation of condition number 41
Okay.
and proceed on violation of condition number 2 on or about the 31st day of March 2025 in Bexar County, Texas. The defendant Deja Rosette Garcia did then and there admit to consuming alcoholic beverages in violation of condition number 2.
How do you plead to that? True or not true?
True.
And then we waive and abandon the remainders, Your Honor.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There's not, Your Honor. The state is asking that you grant the state's motion, revoke the defendant's community supervision, adjudicate her guilty, and sentence her to 2 years in the state jail facility. She was placed on deferred adjudication back in May of 2022, and was a participant of felony drug court until this recent MTR, where she was not in compliance with the program. And so that's why we're asking for the 2 years in the state jail facility.
All right. What are you requesting?
Yes, Judge, we are asking the court to consider the recommendation of the probation officer. We did confer with probation, and their recommendation, as far as I understand it, is to reinstate her with the DDRF. It seems, as far as I understand, Judge, after talking to my client and reading the report is that she did well on DDRF. She did not do well on safety, is what I understand. So I've had communications with her. I have an understanding, a little better understanding of DDRF and the difference. And she does feel that she benefited more with the dual. That includes the mental health
But
component.
didn't felony drug court have her on the dual track?
They moved her, that's a good question, Judge. I believe they moved her from the DDRF to straight safe P is what I understand. And that's where she
Didn't want to go to
went
safety.
astray. I
No.
believe.
So you didn't want to go to safety?
I just signed on it, cause just wasn't in the right state.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Deja Garcia,
So felony drug court, didn't they have you in their dual diagnosis program?
yes, ma'am.
All right, so where are you saying you went off track?
Right, a few months after I got out of DDRS, I got off track again, and that's when they decided to have me sign the safety.
Okay.
Because it was about after 4 or 5 months.
Did you go to safety?
Yes, ma'am.
All right, did you successfully complete it?
Yes.
All right, so then you get out of safety, then what happens?
I slipped up and I drank like on 2 of the violations.
So why did you drink?
Um, I think just because I was kind of overwhelmed when I got out of that facility. So I'm not trying to make it an excuse, but I was just overwhelmed.
All right, so to the court, and if I'm wrong, let me know. There seems that there's more than just this being overwhelmed, because I used to be an attorney in felony drug court. And when you're released from safety or some kind of inpatient treatment, they don't just let you fly free because they know you're going from a lockdown facility to coming out. So they really keep track of you until you're on the right path. Then they let you be freer with your time. So I'm not understanding. So you leave safety and you start drinking.
Yeah, ma'am. A few weeks after I get out, I drank like once or twice.
Mhm.
I
May-
just
may
had
I
a lot
interrupt?
of
Can I say something, Judge?
Sure.
Okay, so I spent a little time with her and I don't know if maybe she's not remembering or the communications we had, we went over the excuses and how just give them the facts and tell them what happened. What I see in this is, I asked her, how did it happen? What happened? What was your plan? What was the goal? How did it work after you got off? You got out just like you just went through with her. What she hasn't said was that she tried to enroll in school. She moved back home, I believe, correct, with your parents. And so that's where we stopped. I think it was a few months ago.
Well, here's the thing. When you move back in with your parents, the felony drug court approved you moving back in with your parents?
no, ma'am.
All right. See, that's part of the problem because felony drug court has rules where you can stay, what you can be doing. When she got out of inpatient treatment at SafeP has an aftercare program, which is what she's supposed to be in, and felony drug court would still keep track of her. So this thing right now, what she's doing, she's not being 100% honest with me. It sounds as though she didn't want to do SafeP, but they made her do SafeP. Then she's released from SafeP and she's in aftercare and she don't want to do that. So she starts doing her own thing. Felony drug court has a dual diagnosis program. And if she had mental health issues that were happening, they would address those. But if it's somebody who wants to do whatever they want to do, drug court is just not going to let you do whatever you want to do.
Correct, and that's why we are asking the court to consider what the probation office has recommended, which was to put her back in the DDR program, Judge. Because I agree, I think she did better in that treatment program versus what we're talking about here on the safety and handing it over to her. She wants that. She wants that reinforcement of the
But she
mental
was
health
doing
component.
But here's the thing, DDRF is in inpatient treatment.
She understands that.
I don't think she's a good candidate for probation. I don't think she's a good candidate. Felony drug court is a very good program.
Yes.
If you follow the rules, but sometimes people don't want to follow the rules. I don't think she's a good candidate for probation.
I believe this was only as far as I know, Judge, from what I can speak to is the report, this was the only violation that we have on her, and it was right after safety.
But see, here's the thing about that. Felony drug court, when people come back to this court from felony drug court, yeah, that's the only violation they have because felony drug court is sending them back. But when you're in felony drug court, they don't automatically kick people out of the program. They go through different steps, graduated sanctions. So they have technically, probably in felony drug court, she could have probably had 10 motions to revoke by now, but they don't do that. And I'm sure there's a reason why they did not approve her living with her parents. And part of that reason is because of the drinking. And they knew that they had probably already tried that before with her living at home and they told her no, but she wanted to do what she wanted to do. So now we're here and I don't think she's a good candidate for probation.
I just feel, Judge, that the element of putting her straight into the state jail felony detention center, it just squashes the whole program of rehabilitation. I think she agrees. If it's gonna mean more time, Judge, I think that the benefit would be there for her to do the mental health component. She clearly knows that she needs that help, as far as I know, and she's being fully, as far as I know,
Yeah.
you know. just
But
put-
felony drug court was giving her that. She didn't want it. She wanted to do her own thing. And I don't think she's a good candidate.
Okay, I understand.
All right, the court is going to grant the motion, find you guilty, revoke. Now, the next question is, state you're asking for 2 years?
Yes, Judge.
All right, and state, why are you asking for 2 years?
Judge, she was in the felony drug court program. They did do graduated sanctions with her. That included the DGRF and Safe P. And she just still could not comply with the terms of probation. So that's why we're asking for what we're asking.
All right, and how much, what are you requesting?
Credit for time served, I believe she's already been there a little over 12 months. Doing the program, Judge, that's already 12 months that she's been in custody, I believe.
All right, the court will sentence you to 2 years in the state jail facility, give you credit for any time served. And I'll give her credit for any successful inpatient treatment. If she successfully completed DDRF, then she'll receive credit for that. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you when you're released from custody. If you're still trying to find help with your mental health or maintaining your sobriety, if I'm still here, you come back here, I'll pick up the phone and call for a placement for you. All right, good luck to you. Who is here on Brennan Smith? Are there applications or no? All right, court is calling 2025 CR 002749 and 2025 CR 005428, State versus Brennan Smith. Can I have parties announce?
Andrew Harris, Salem for the state.
And are you Mr. Smith?
Yes, right.
Counsel, have you received all discovery and did you review it with your client?
Yes, I have.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, Mr. Smith, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment? State in cause number 49, are you proceeding on the indictment as presented?
Yes.
And in cause number 28, are you proceeding on the indictment as presented?
Yes.
Mr. Smith, did you review the documents entitled court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand that you're charged with, in the cause number ending in 49, you're charged with collision involving an injury with a range of punishment, not more than 5 years in TDC or not more than 1 year in the county jail with a possible fine up to $5,000. And the cause number ending in 28, you're charged with evading arrest detention with the vehicle as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have plea bargains with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into these plea bargain agreements, you are giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so.
Do you believe he's currently competent and was legally sane at the time of the offenses?
I believe so.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page in each of these cause numbers?
Yes, Your Honor.
According to the plea, punishments be assessed at 2 years in the prison. And the cause number ending in 28, there's a $2,000 fine. And the cause number ending in 49, there's to be restitution payable to Andrew James Branham and Catherine Ann Forshon. And the cases will run concurrently, and the state will take in consideration 2025 CC 001264 and 2025 CC 001262. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It is.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
None.
And the cause number ending in 49, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
And the cause number ending in 28, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendants, please.
In each case, state offers exhibit 1 and attachments.
All right, and state, have you spoken with the complainant?
That I don't know.
All right, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. In each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, we are.
Anything you wish to say on behalf of your client?
Nothing.
All right, and the cause number ending in 49, the court will follow your agreement, sentence you to 2 years in the prison, give you credit for any time served. Take into consideration 2025 CC 001264, 2025 CC 001262. This will run concurrent with 2025 CR 005428. There's to be restitution, if any, to Andrew James Branham, Branham, and Catherine with a C, Ann with an E, Forchion, Forchion. Is there anything else with regards to sentencing under that cause number?
Nothing further.
And cause number ending in 28. As previously stated, the court is finding you guilty. The court will sentence you to 2 years in the prison, give you credit for any time served. There's a $2,000 fine. Time and money will run concurrently. This will run concurrent with 2025 CR 002749. taking consideration 2025 CC 001262, 2025 CC 001264. And I forgot to ask, is there a need for the therapeutic community for him? Did you review, and each cause number, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And each of these cause numbers, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
20. I just turned 23 days ago.
All right, so here's the thing. You've got yourself in a pickle, right? You're gonna have to make better decisions. It's not the end of your life, it's the beginning of your life. If you come out and continue to behave the way you're currently behaving, you're gonna find yourself living at somebody's Bear County jail and at somebody's prison. You understand?
Yes.
When you get out, if you have a problem with sobriety, if prison has been a little bit harder than you think it is, and you need some help with mental health, if I'm still here, you can come back here and I'll find a placement for you, okay?
Thank you.
All right, good luck to you.
Two.
Court is calling 2024 CR 006824 State versus Marco Marino. Can I have parties announced?
Jones for the state.
Christine Brown for the defense.
And are you Mr. Marino?
Yes, ma'am.
Did your counsel, have you received all discovery? Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Mr. Marino, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do waive the reading of the indictment.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding on count one only, so waiving counts 2 and 3. And for count 1, we are proceeding on the lesser included offense of aggravated sexual assault of a child.
You wanna put that on here?
What I did, Your Honor, can you back up? Let's say.
Oh.
All right. Did you review admonishments? I'm sorry, any objections to the waivers?
No objections to the waivers.
All right. Any objections to proceeding under count 1 of aggravated sexual assault of a child?
There's no objection.
All right. Did you review the admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on count 1 aggravated sexual assault of a child? That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That I do.
Mr. Marino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a US citizen?
Yes.
All right, let's go off the record for a moment. All right, we're back on the record. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to life in prison and up to a $10,000 fine?
Yes.
Mr. Marino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a US citizen?
Yes.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one, aggravated sexual assault of a child. They're asking that the punishment be assessed at a cap of 12 years in the prison. There's a $1,500 fine. The state is opposed to your application. There's to be Chapter 62 compliance and also no contact with the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, the meaning of such motions?
No, not that I.
Then to count one, aggravated sexual assault of a child, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states exhibit 1 and all attachments.
Any objections?
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and cite it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, I can set this for a PSI. That will be 6 to 8 weeks, or if you all just have witnesses and you want to go without PSI and bring in your witnesses, I can give you a shorter timeline.
Okay, we would opt for the PSI.
All right. Is there a need for a TAP evaluation?
No.
All right, need a PSI date, please? July 15th? All right, we'll be back on July 15th. At that time, I'll make a decision on your application. All right, thank you.
Thank you.
All right, Randy Folsom.
Well, Judge, this is an off-docket matter, scheduled for tomorrow. I did meet with him recently,
Mhm.
and some of the things that we were discussing about did cause me to think that there's some competency issues, especially speaking with him and gearing up for trial, that I don't believe he was just helping me with his defenses, or that he had a factual, rational basis in terms of the proceedings, Judge.
Okay,
So in order for me to do my due diligence, I did file that motion for comp evaluation. The state was served on it. They
Mhm.
did view it, and it is there for the court to view as well.
well, legally, once an issue of competency is raised, then he has to have his competency hearing.
Yes, Your Honor.
Really, at this stage, our only question was whether the court would sign the motion in the absence of Mr. Folsom.
Yes. Based upon what defense counsel is telling me and the fact that he's an officer of the court, I will.
Thank you, Your Honor.
So what we will do is this will be, they may have a quick turnaround down there. Norma, set this for June 18th. Are you here June 18th?
Yes, Your Honor, I'll be here.
All right, set it for June 18th. And let the judge know that this is a bench trial.
And if it's around the June 18th and I receive an update from the MAG court that is still pending, may I update the court at that time?
Yes. All right, thank you. Deputy Laura, you can take him off for tomorrow. All right. Ambrosino, who do you have?
I have Charles Fleming.
I haven't received that as soon as I. Who do you have?
Sandra Oberlander.
All right, is she here?
She is, yeah, we were
Ever come up?
conferring with Mr. Edelman, with a witness in the case, provided him some useful information. I think Mr. Edelman is gonna look into.
I'm
And I think,
required to investigate.
Okay,
and I think the witness is also gonna present some additional documentation to me.
okay.
Since Ms. Overlander travels from Colorado, may we reset this for something slightly longer than 30 days, Your Honor?
Well, let's set it for a jury trial, and then if you all figure things out before the jury trial date, then that's what we will do. How long do y'all expect this trial to last? 2 days?
2 days.
All right, Ms. Ferguson, I need a jury trial date, criminal trial division, 2 days. No, that's too close because she's traveling from Colorado. Put it in July.
So I'm out from the tenth to the seventeenth.
Hmm?
I'm out from the tenth to the seventeenth.
In July? Okay,
Vacation.
so,
Yeah, good work.
all right, so that will be July 22nd. That day, if there is a plea bargain agreement, then you all can do it by Zoom. If not, then you'll need to be here for a jury trial. All right, are there any other questions? All right, thank you.
Thank you.
You too.